I challenge Dr. Ayini to show any memorandum presented to him by the Prosecution's Division of the Office of Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecutions, the DPP, before discontinuing the cases. You can be assured he cannot produce any. Listening to Dr. Ayini, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law on the subject matters in question. It is for this reason that the claims of alleged defects in the various charges only re-echo positions articulated by the defense counsel throughout the various proceedings. In effect, Dr. Ayini came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel on the charges their clients had been charged with. The media would notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter non-repository and withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interests of the Republic in the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayini that he did not consult the former president, John Dramani Mahama, before taking the monumental decisions to discontinue the criminal cases. The cases involve the loss of colossal sums of taxpayers' money and some related to the banking sector crisis, which affected the Ghanaian economy. Dr. Ayini was sworn in as Attorney General on Wednesday, 22nd January 2020. Friday, 24 January 2025, he caused to be filed a notice of abandonment in Republic vs. Ato Forson and 2 others. On Tuesday, 20 January 2025, we withdrew the case against Dr. Ajumako and 2 others, resulting in the complete whitewash of their crimes by an acquittal and discharge through the back door. On 29 January 2025, he entered another withdrawal in Republic vs. Okosuamfo and another, again resulting in an acquittal and discharge of the accused. 3 January 2025, Dr. Ayini withdrew 2 different cases against Dr. Johnson Pandit Selma, resulting in his acquittal in one and a discharge in the other. Entered by the NDC government through the Attorney General subsequent days. Indeed, hot brewed a trend of 1 day. Ladies and gentlemen, this development irresistibly to only one conclusion. Preconceived ploy on the part of the NDC to wipe out all criminal cases against its leading members and officials of the John Mahama government and clear them of wrongdoing not by the courts, but their Attorney General. Remarkably, there is no precedent for this kind of conduct in the Fourth Republic. Throughout the 2 8-year terms of the MPP government, no Attorney General appointed by either President withdrew criminal charges in cases involving leading members of the MPP or senior members of the government. At the time the MPP assumed office in 2017, all the cases filed by the SWA NDC government against some ministers of the Kwan government and other appointees have been contested fully in the courts and won.
That case is in Attorney General no chere say ase ebi o hwa eni nyina so ebi o hwa apepa no unim say odi kan akoyi no mu ama but nura say nani 3 days or your press conference e chere ye owura Dominic ayene adenti
me hu ni say eguna ni mase
Samum,
I'm telling you.
And for Bonabasu, and Pembe, but for this one now, Baba Betches, and America say, Bonabasu,
Yamahuaye, Manase, and Wabonaba, Nyungo Bebre. Here, it's still an Ababa such high profile cases. Settlement are 200 million involved.
And no one can say Manase can say hold your own funnies.
Meba. Senate. I was in the public brain. I'm so Manase na mate.
But Manase born about no can say.
Yankan you are born about no
Ora Collins out that you should have allowed the case to run.
Nyame can say wo say Manase na born about so be and sign am say aye. Dodo bebre. 66 million involved dollars. I was Senate case. In your Siama case, and no kind of bizarre. I don't know, over 400 million involved. And then Attorney General is telling us, Cabinet is not aware, President is not aware. What kind of governance is that?
Oh, so no age. And no buy and what steady docket.
Yeah, age, you know. You don't work on your own. When are we the foremost legal representative of the government?
Okay.
When are you number one? When are you president, lawyer? President, they use when are you attorney?
Okay.
State, when are you number one? Are you leader of the bar? Eti wo ye adwuma ama obi. President na wo ye adwuma ama no. Eti attorney general kan obeka che kwampo say president is not even aware. Say okọ court akwa akotwa settlement. Case are involving $200 million wom. Okọ court akwa akotwa a Senate case are involving $66 million. Okọ Bank of Ghana case a year banking sector collapse hereby. Okọ akwa akotwa case are involving over 400 million Ghana cedis. Okwa akotwam. Yeah, this is serious. What kind of governance? Yes.
And see, that time na urada me air trial Ato Forson no and the Richie Japamo leaked tape.
No briefing.
Not president then.
No briefing or cabinet.
Oh, okay.
All of that. These are because now some are buying or acting through the cabinet. So either you back briefing president.
Okay.
And no briefing cabinet.
Okay. So Wora Johnson esiama de no say na enyo no kwa no stand trial na ebi mu kan ho.
And you no kwa
but ono pe no yi ni free mu. And we obema nchemu say ayete say ye de no na akofra.
Dabi. Or ye deputy governor.
Okay.
Na ono na banking sector no kuta supervisory role.
Okay.
Banks no ego. And ono na akwa approve close to about 400 million or so any senka. Or approving.
Okay.
And now, ya didn't court say on answer. Who said there be only on count? It was because
you didn't court everything.
Oh, Menkai and Weber. Menkai said from 2019. I think it started 2019, 2020.
So say 2020 cry. It's been like 4-5 years now. Inti Argentina Ora Dame so and ye chidemi and then also become wheel of justice. This load.
So Sanya be Canada. Oko court ahụ ya won some edit 10 years old and attorney general enko clear obia ya won edit 12 years old ya won some ni bi wo ho no ma e wo se ya edit 13 years e wo ho and you won ka say because of that thing ya you obi afrim ya kan sa
you won say no credit ye
wo ayi case edit say court eno ma hu say ayi ye free person na onam ho no se ya opening nyantichi me boa
question nyantichi
yes e go dis enya 5 years
yeah
enye na no court akasa
yeah
so what's the problem
so one who said
issue is a court almost be 4-5 years old. Said nam tamaklo no.
Okay.
Yes, na court can once.
Okay. But there may be some say it will be
NCA DA. And also I was in court for almost about 4-5 years.
Okay.
So what is wrong with that?
Okay.